at ttparliament.org. The printed version of the bill will be available in limited quantities at libraries across the country.
The Honourable President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath of affirmation, announcements by the President, bills brought from the House of Representatives, petitions, papers.
Minister of Agriculture, Land and Fisheries.
Madam President, my apologies. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in my name. The Ministerial Response of the Ministry of Agriculture, Land and Fisheries to the 7th Report of the Public Accounts Enterprises Committee, 2nd Session 2016-2017, 11th Parliament on the examination of the audited accounts, balance sheets, and other financial statements of the Estate Management and Business Development Company Limited, EMBD, for the financial years 2008 to 2010. Thank you.
Madam President, I have the honor to lay on the table the following papers listed on the order paper in my name. The response of the Service Commissions Department to the 9th report of the Public Accounts Committee, 3rd Session 2017-2018, 11th Parliament on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Health.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honour to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The consolidated audited financial statements of the National Gas Company of Trinidad and Tobago Limited for the financial year ended December 31st, 2017.
Minister of Public Utilities.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in my name. The annual audited financial statements of the Water and Sewerage Authority, WASA, for the year ending September the 30th, 2013.
Minister of Rural Development and Local Government.
Thank you, Madam President. I have the honor to lay on the table the following papers as listed on the order paper in my name. The annual administrative report of the Arima Borough Corporation for the years 2014 to 2015 and 2015 to 2016. Thank you very much.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Housing and Urban Development and the Minister of National Security. The ministerial response of the Ministry of Housing and Urban Development to the 11th report of the Public Accounts Committee, 3rd session 2017-2018, 11th Parliament, on the examination of the audited financial statements of the Land Settlement Agency for the financial year 2008-2009. The annual report of the Strategic Services Agency, Ministry of National Security, for the year 2015.
Reports from committees, urgent questions.
Senator Mark.
Thank you, Madam President. To the Honourable Minister of National Security, can the Minister indicate whether any of the 82 Venezuelans who were recently deported were in possession of asylum certificates?
Minister of National Security, you have 2 minutes.
Thank you, Madam President. Madam President, 82 Venezuelan citizens returned to Venezuela on Saturday, the 21st of April, 2018, aboard a Venezuelan military aircraft sent by the Venezuelan government for the return of their citizens. 3 of the voluntary repatriates applied for and obtained asylum-seeking certificates from UNHCR, but expressively abandoned their asylum claims in writing via the UNHCR's agent, Living Waters Community. These persons also expressly and voluntarily agreed to their repatriation on 2 separate occasions, which were recorded, Madam President.
Senator Mark.
Madam President, could the Honourable Minister provide this Senate with the information in documented language as it relates to those 3 Venezuelans who we are told applied and later reneged? This is what we are being told, Madam President, by the Honourable Minister.
Senator Mark, you're asking for the documentation.
Yes.
Minister.
Madam President, I'm pleased to do so, subject to Cabinet's approval.
Senator Ramdeen.
Thank you, Madam President. Madam President, through you to the Honourable Minister of National Security. Could the Honourable Minister of National Security indicate to the Senate whether legal advice in a language that the Venezuelans could have understood or any type of advice were provided to these persons before they voluntarily, according to the Minister, decided to be repatriated to Venezuela?
Minister.
Madam President, the repatriates, Venezuelan citizens were in fact counseled by the ambassador of Venezuela to Trinidad and Tobago. She dealt with matters pertaining to that, Madam President.
Next question, Senator Mark.
To the Honourable Minister of National Security, given the concerns raised by the United Nations Resident Coordinator in Trinidad and Tobago in respect of the deportation of 82 Venezuelan nationals. Can the minister indicate what is in place to protect asylum seekers?
Minister of National Security.
Thank you, Madam President. Madam President, let me just correct one aspect of the question. And it's not, citizens were not deported from Trinidad and Tobago, it's voluntary departure. Madam President, the Ministry of National Security continues to hold discussions with UNHCR rep in Trinidad and Tobago. As a matter of fact, they've also been joined by the Attorney General. So between the Attorney General and Ministry of National Security, we continue to hold discussions with UNHCR residents here in Trinidad and Tobago. Madam President, Trinidad and Tobago acceded to the 1951 Refugee Convention and the 1967 Protocol relating to the status of refugees in 2000. This has been noted, Madam President, that only the United Kingdom thus far was ratified this treaty. No other country has done that so far, only the United Kingdom. And therefore, Trinidad and Tobago has not enacted those laws within the domestic legislation of Trinidad and Tobago. Madam President, standard operating procedures are in place in Trinidad and Tobago to deal with this. These procedures involve a process of applications for claims to the UNHCR via the agent for the UNHCR, the Living Waters Community, or via the Immigration Division. All applicants are required to obey the laws of Trinidad and Tobago. The UNHCR informs the Immigration Division of applications and persons who may be put on orders of supervision, if possible. That is after UNHCR have gone through their processes. The UNHCR engages in an investigation of the claims to establish whether the applicant expresses a fear of return to his country of origin or last habitual residence based on a well-founded fear of persecution. That is, reason of race, religion, nationality, membership of a particular social group or political opinion, and qualifies as an asylum seeker. This investigation is to be done within a 3-week period. The applicants are accommodated by the agent for the UNHCR, in which case is the Living Waters Community in Trinidad and Tobago. Compliance with the laws of Trinidad and Tobago is mandatory.
Senator Mark.
Madam President, could the Honourable Minister indicate whether the standard operating procedures outlined by him are in contradiction or inconsistent with the guidance note issued by the United Nations High Commissioner for Refugees on March the 18th, 2018. Could you tell this Honourable House if there's a contradiction or if they are in harmony?
Well, Senator Mark, that question does not arise. If you just have a look at the question that you have posed, and you may ask another.
I'm dealing with what the response.
Yes, I know, but the question still. The question, could you ask another question, please?
Okay. Madam President, may I ask the Honourable Minister whether the existing protocols, well, no, not protocols, because that's another question that is on the order paper. But the question that I would like to pose to them is whether Trinidad and Tobago, as a signatory to this particular 1951 convention, whether asylum seekers are required under international law to be granted certain protection by the government of the Republic of Trinidad and Tobago.
Minister of National Security.
Madam President, I mentioned a while ago that the laws have not been enacted in Trinidad and Tobago. The procedure that I mentioned a while ago is done between UNHCR and the Living Waters Community. Living Waters Community acts as the local agent. We refer the applicants to UNHCR, who deals with it. There are no laws. The laws have not been enacted in the domestic laws of Trinidad and Tobago.
Madam President, in light of the fact that we are a signatory.
Senator Mark.
No, you're told
that's your second question. Next question, Senator Mark.
I thought you were going to be lenient.
Next question, Senator Mark.
Not today. That is Jack Warner. Not today. Madam President, may I ask the other question? to the Honourable Minister of Rural Development and Local Government. Can the Minister indicate what action is being taken to ensure that the Chaguanas Municipal Police officers are outfitted with functional firearms?
Minister of Rural Development and Local Government.
Thank you, Madam President. Madam President, I would like to thank the Honourable Member. As the issue of equipping our municipal police to ensure the safety of our citizens is an extremely important one for the 14 corporations and by extension the government. The Assistant Commissioner of Police is handling this issue and it is receiving his urgent attention. The Inspector of the Chaguanas Borough Corporation has been asked to submit the name of the provider for the firearms, which was supposed to accompany the request for the clearance to purchase the weapons. And once this information is provided, the approval process can move forward right away. The procedure is that the name of the provider must be submitted to the Commissioner of Police with the request for clearance to purchase firearms. In the case of the Chaguanas Police, the first request was lost by the Office of the Commissioner of Police, and a new request was submitted in November 2017, but without the name of the provider. The inspector of the Chaguanas Corporation was contacted yesterday to submit the name of the provider so the process can be completed. Thank you very much.
Madam Chairman, Madam President.
Well, actually, Senator, time, honourable members, for urgent questions has expired.
Questions on notice, questions for oral answer.
Madam President, the government is pleased to announce that it will be answering all questions, save and except question number 64. As you recall, on the last sitting, the Standing Order 2715 was invoked. I've been informed by the Minister of Finance that you'll be getting your reply tomorrow, and the answer will be available at the next sitting of the Senate.
Senator Mark.
Thank you, Madam President. Question number 85 to the Minister of Housing and Urban Development.
Acting Prime Minister.
Thank you, Madam President. The housing development at Malabar Site 3 is still under construction, and as such, no units have been distributed to date.
Senator Mark.
Madam President, could the Honourable Minister indicate when the construction of this particular housing development project is expected to be completed?
Acting Prime Minister.
President, I would have been happy to answer that question if it had been asked. I was asked about distribution of units for a site that is incomplete. I will provide the information once the question is posed in the established manner.
Senator Mark.
Madam President, could the Honourable Minister indicate how many units are expected to be established at this Malabar Site 3 housing development project?
Acting Prime Minister.
Again, Madam President, I'll be happy to provide that information if the question is posed in the proper manner.
Your record stuck. Could I ask through the Honourable President whether the Minister could indicate to us the name of the contractor that has been recruited for this particular site development? Madam President.
Senator Mark, that question doesn't arise. You have one more supplementary on this question.
Madam President, could the Honourable Minister share with us, Honourable House, whether it is the intention of the government to have this housing project completed within the shortest possible time frame?
Senator Mark, that question also doesn't arise. Next question, Senator Mark.
Question number 87 to the Minister of Housing and Urban Development.
Acting Prime Minister.
Thank you, Madam President. The East Grove housing development at the Southern Main Road in Curep does not require the approval of Parliament. The National Physical Development Plan, 1984, however, did receive the approval of Parliament. This plan guides the development of all land in Trinidad and Tobago. The Town and Country Planning, through its land use policies and approval process, considers whether a proposal, for example, the East Grove housing development, is consistent with the approved National Physical Development Plan and current land use policy for any area in question. Under the Town and Country Planning Act, Chapter 3501, the minister responsible for Town and Country Planning can amend the land use policy for an area. Outline planning permission was accordingly granted to the East Grove housing development proposal on October the 12th, 2017. No recent survey was undertaken by the Ministry of Housing and Urban Development for the East Grove housing development at Southern Main Road, Curep.
Senator Mark.
Madam President, could the Honourable Minister of Housing and Urban Development indicate to us whether the Minister of Planning and Development can alter the National Physical Development Plan and grant approval of same for housing without the express approval of the Parliament?
Minister, Acting Prime Minister.
Thank you, Madam President. As I indicated in the body of the answer, under the Town and Country Planning Act, Chapter 3501, the minister responsible for town and country planning can amend the land use policy for any area.
Can the Honourable Minister of Planning and Development amend this policy without reference to the Parliament, which was initially responsible for its approval? That is the National Physical Development Plan, Madam President. Can that be done?
Senator Mark, didn't you just ask that question?
Well, he hasn't given me a proper answer. That's why I'm asking it again.
Okay, so can you now ask a third question then, Senator Mark?
Madam President, may I ask why a recent or why a survey on this particular property or piece of land at St. Augustine, where the government intends to erect housing for political purposes? Can the minister indicate to us why a survey was not conducted, Madam President?
Acting Prime Minister.
Thank you, Madam President. At no time did I say that a survey was not conducted. I said no recent survey was conducted.
Could the Honourable Minister indicate to this House when was the last time a survey was conducted on this particular site? Madam President.
Acting Prime Minister.
Thank you, Madam President. I do not have those details, but I have seen the survey plan, and I will obtain the information and provide it to the Honourable Senator once you pose a question in an established manner.
Next question, Senator Mark.
Question number 96 to the Minister of National Security.
Minister of National Security.
Thank you, Madam President. Madam President, information received from the Strategic Services Agency indicates that there were delays of reimbursement to the National Helicopter Services Limited for payment of salaries to employees of the Air Division of the SSA for August and September 2017. The SSA has also indicated that said payments were made in November and December 2017, respectively. Further, the salaries of the Air Division of SSA pilots are current as at March 2018. Additionally, Madam President, to ensure that pilots are paid in a timely manner, the SSA has expressed its dedication to continually ensure that invoices are submitted on time in order to process timely payments to NHSL.
Senator Mark.
President, could the Minister indicate to this Honourable Senate whether any dislocation resulted from this lack of timely payment in the period mentioned, August and September of 2017, in terms of the work of these pilots as it relates to national security?
Minister of National Security.
Madam President, I'm not too sure what Senator Mark means by dislocation. I don't know if you want to amplify that, please.
Could the Honourable Minister indicate whether, as a result of the action taken by the pilots, whether it resulted in any untoward developments at the level of the operations of these helicopters for national security purposes?
Minister of National
Madam
Security.
President, no.
Could the Honourable Minister indicate, Madam President, what were the factors that would have led to the delay, Madam President, in the payment of salaries for the months of August and September of 2017?
Minister of National Security.
Madam President, I thought I answered that in part when I said the timeliness of invoices, and SSA has made a dedicated response to ensure that invoices are submitted on time.
That is what he said, and that is why I asked the question, because I realized it was in part. Could you give the Senate a full account as to why this development occurred in that period that led to the action taken by the pilots? Could you give us a full account?
Senator Mark, the Minister has answered that. Could you have another question you need to ask?
Well, I just simply wish to ask...
Just ask. Pose the question.
Yes. But you're not giving me a chance to ask. I want to ask. May I ask the Honourable Minister of National Security, how can we, in the future, avoid this kind of development as it relates to that experience that we had in August and September? What steps, in other words, will be taken to avoid this in the future?
Senator Mark, that question has been asked and answered. Next question, Senator Obika.
Thank you, Madam President. Question number 96 question number 115 to the Minister of Health.
Leader of Government Business.
Thank you very much, Madam President. Madam President, 18 approved private healthcare providers are being utilized in the provision of dialysis services. That's in answer to Roman 1. Roman 2, the total cost of dialysis services paid for by the ministry over the period September 2015 to February 2018 is $170,691,658.
Thank you, Madam President. Could the Honourable Minister indicate, placate the fears of persons where there are reports of some half a dozen odd dialysis centres that are struggling to remain open due to timeliness or lack of timeliness of payment, honouring of invoices by the government?
That question does not arise. Next question, Senator Mark. Senator Obika.
Senator Ramdeen.
Senator Ramdeen.
Madam President, through you to the Honourable Minister. Minister, what steps are being taken by the government to provide this dialysis service through the public healthcare system instead of utilizing private centres to the extent of the funds that you've indicated have been paid since September of 2015?
That question also does not arise, Senator Ramdeen. Next question, Senator Obika.
Thank you, Madam President. Question number 116 to the Minister of Education.
Minister of Education.
Thank you very much, Madam President. In September 2017, the NESC consolidated its courses at locations across Trinidad and Tobago in response to the demand of the public and the needs of industry, in particular, the energy sector. This was not a move to downsize the organization. Instead, the actions implemented are in keeping with the strategic direction of the NESC to establish specialized training institutes. The Point Fortin location has served its purpose as the demand for the courses offered has fallen significantly, and industry has indicated to us the need for a journeyman professional tradesman over a semi-skilled worker. Interested applicants in the area of Point Fortin want to be part of a campus that has both the facilities and atmosphere of a tertiary institution, such as the campuses at Point Lisas, St. Madeleine, and the Library, which are easily accessible and have the available capacity to accommodate these students. Students of the Point Fortin campus were redirected to the Library campus. As a result, there will not be a negative impact on skills development needed for industrial advancement. There is a low demand for programs at the Point Fortin campus. Although the campus has a capacity of 96 students, only 29 applications were received, and, Madam Speaker, only one student registered for the academic year 2017-2018. Additionally, the registration at the Point Fortin campus has been declining over the last 3 years, from 166 in 2015-2016 to 56 in 2016-2017 and 1 in 2017-2018. NESC has served the Point Fortin community for some 20 years with different generations trained over that period. We hold to our responsibility to provide relevant education and training to all interested members of the public, as it is in keeping with our mandate and in an environment that is conducive to their personal development. The closure of the Point Fortin campus is simply a relocation to where the training occurs, from a smaller, restricted center to a larger campus. Thank you.
Senator Obika.
Thank you, Madam President. Could the Minister indicate, given the 20 years that the NESC has served Point Fortin, if it would not have been some issues regarding the competence of the staff in Point Fortin to promote the programs of the NESC over the last 3 years, which resulted in the decline?
Minister.
Madam Speaker, the information that is before me that I got from NESC does not include competence or incompetence. It is simply a statement of fact. And the fact is that in the academic year 2017-2018, only one person applied. And therefore, the question of competence or incompetence does not arise. Thank you.
Thank you, Madam President. Could the Honourable Minister indicate whether it is a question of lack of resources given to the NESC in Point Fortin by the government, which resulted in this drastic decline after having served Point Fortin for 20 years?
Senator Obika, that question doesn't arise. Next question.
Could the Honourable Minister indicate how many students from Point Fortin are currently in the NESC programs in Vesini and in Point Lisas?
Minister.
Madam President, I simply can't answer that question at this juncture. I don't have that information.
Thank you, Madam President. In light of the fact that the Paloseco and the Moruga campuses have closed, and in fact, there are persons from the NESC who have reported that the campus in Vesini has been narrowed in its specification of courses. Could the Honourable Minister indicate if any support for transportation costs, which could range from $800 to $1,200 per month, for persons from Point 14 to attend classes in Point Lisas.
Have a seat, please. Are you debating or are you asking a supplementary question which must be focused to the minister? You decide. Just put a simple question to the minister, please, and not be debating all that you're saying, okay?
Thank you, Madam President. Could the Honourable Minister indicate if any financial support for transportation will be provided for the Point 14 students given the dislocation? Minister
of Education.
Madam President, again, that question doesn't arise. One person applied. One person. So the question about transportation support simply does not arise. Thank you.
Next question, Senator Obika.
Thank you, Madam President. Question number 117 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, in August 2017, the government agreed to the reconstitution of the Board of Directors and to the appointment as advisors to the board persons with specialist skills and knowledge in the oil and gas industry. The Board of Directors was given a mandate to govern and manage the company as a competitive business and as a sustainable, profitable entity. In the process of the execution of its mandate, the board had to contend with the resignation of Petrotrin's president, the vice presidents of human resources, exploration and production, refining and marketing, and the senior manager, strategy and business development. This created a void in the management of the organization. The board is currently in the process of identifying and recruiting suitable persons to fill these managerial positions. In the interim, to ensure continuity in the management of the organization and the plans of its viability, government agreed to the appointment in an executive capacity of members of the board and advisors with the requisite skills and experience to head the position, to hold the position of head of refining and marketing, head of finance, and head of exploration and production, health, safety, and environment. These appointments are for a period not exceeding 6 months. The board and management are responsible for the conduct of the restructuring of the organization. However, the Board of Directors has engaged external consultants with specific industry expertise and experience to advise the board on the strategic issues related to the achievement of its mandate.
Senator Obika.
Thank you, Madam President. Could the Honourable Minister indicate to this Honourable House who are these external consultants?
Minister.
As I said, the external consultants with specific industry expertise to advise the board on the strategic issues, not to implement any restructuring. However, two of the world's most renowned internationally known consultants, the company of Solomon and Associates and the company of McKinsey, have been recruited by Petrotrin to advise on these strategic matters.
Senator Obika.
Thank you, Madam President. Given that we now understand that there are consultants, could the Honourable Minister indicate if there's any budgetary allocation for them or what would be specific costs regarding their engagement?
Minister.
I do not have with me the specific cost of these arrangements, but I can easily find that out from Petrotrin.
Senator Mark.
Could the Honourable Minister indicate, Madam President, for what period of time would these external consultants be engaged?
Minister.
It is not a time charter, so to speak. It's not a time-based contract. They have been recruited to provide advice. They have done several strategic studies, benchmarking the companies against the international benchmarking specifications. And these reports have been submitted to the Petrotrin management, and they are using that as the guideline in their restructuring process. And these companies periodically supply support in these initiatives.
Senator Mark.
The three personnel that the Honourable Minister referred to who left or retired from the organization, can the Minister indicate, Madam President, whether these persons were constructively dismissed by the board of Petrotrin?
Minister.
The answer to that is no. There was a mutual understanding for the cessation of the employment of these three senior managers. They left on mutually agreeable terms, and it was felt that they wanted to give the board a free hand in putting in place a new management.
Public business, private members' business, motions.
Honourable Senators, the debate on the following motion, which was in progress when the Senate adjourned on Tuesday, March 27, 2018, will be resumed. Whereas financial and administrative autonomy of Parliament is an undisputed benchmark of a true democracy, and whereas a legislative proposal entitled the Houses of Parliament Service Authority Bill 2014 was laid in Parliament and referred to a Joint Select Committee in 2014. And whereas the Joint Select Committee agreed that parliamentary autonomy is essential to the recalibration of the existing relationship between the executive and the legislature, and whereas the government, in adopting the 2015 manifesto of the People's National Movement as its official policy framework, confirmed its commitment to the principles of parliamentary autonomy, be it resolved that the Senate call on the committee to introduce legislation by April 30th, 2018, to give effect to parliamentary autonomy, and that this legislation be immediately referred to a Joint Select Committee of Parliament for early consideration and report. Honourable Senators, over the course of Tuesday, March 6, 2018, and Tuesday, March 27, 2018, some 14 members have already spoken, including the mover of the motion. Minister of Agriculture, Land and Fisheries.
Madam President, I'm pleased to join the debate on this motion.
Just 1 second, Minister. Senator Obika.
Oh, he hasn't finished.
President, I was of the understanding I had some time remaining in my presentation. I apologize for...
Senator Obika, my apologies. You have 23 minutes.
Thank you, Madam President. You are most gracious. You are most gracious. And I am always happy to make my contribution, given that it's really few people who have the opportunity to do so in the Parliament of this great Republic of Trinidad and Tobago. I would like to start this second half, as it were, of my contribution with the concept of the Latimer Principles. And I would like to read from the Commonwealth website, if I may be allowed to do so. The Commonwealth Latimer House Principles govern issues such as the harmonious balancing of power and the interaction between Parliament, the executive, and the judiciary in democratic societies. They set out in detail the consensus arrived at by representatives of the three branches of government in the Commonwealth on how each of their national institutions should interrelate in the exercise of their institutional responsibility. The principles specify restraint in the exercise of power within their respective constitutional spheres, so that the legitimate discharge of constitutional functions by other institutions are not encroached on. The separation of powers principle, Madam President. And if I may look to another document, building on that trend, it's a paper delivered by the Speaker to the Gauteng Provincial Legislature, Republic of South Africa, Honorable Lindiwe Maseko, 15 to 19 September 2013. So The paper regards the financial independence as a means towards effective oversight. And at the beginning of my presentation at the last sitting, at the last private members' motion sitting, I alluded to a saying that we have in Trinidad and Tobago, and as well globally: who pays the piper calls the tune. And where the Parliament is concerned, the notion of autonomy rings true and is in sync, in harmony with that saying. And this paper begins by saying the constitutional division of powers between the three arms of the state is the base for striving towards a strong and an independent Parliament. Now, the division of powers really and truly is a concept that I'm sure will not be lost on members on the other side, and I'm sure members on the independent bench. And it's really a tenet that strikes at the core of what we are doing here, democracy. And given that we are to be guided by the principles that were set down at Latimer House, we really must appreciate that importance. I want to go to a local example of fiscal federalism. Now, fiscal federalism rests on the concept that monies of the state is best administered at the local levels rather than the centralized level of the state. What does that mean for the layperson listening? Persons recognize the importance of local government in the delivery of social services and localized infrastructure such as box drains and secondary roads, etc. And the concept of fiscal federalism is, whilst we are not saying we want a political federation within Trinidad and Tobago, we may benefit from a fiscal type of federated state. So the state is federated only along the lines of generation of revenue and allocation of some aspects of the revenue. Central government still has a major role to play in setting the pace and in also spending the majority of the government's budget and taking charge of most of the government's debt. However, some level of devolution can happen at that level. Now, how is that linked to parliamentary autonomy? All of that, Madam President, forms part of the story of the separation of powers. If at the level of the Parliament there is autonomy, then it becomes much more palatable. I'm looking for the pronunciation that would please the Honourable Minister of Trade. I think it would not be possible for me. But that will be palatable to all the members of Parliament. So, for example, if the government sees it fit to have the Parliament be autonomous regarding its financial independence, then it becomes easier now for each and every elected member of Parliament, Madam President, to have some portion of the fiscal allocation. That is the appropriation bill. So, and I would like to read this short part of my presentation, as I have not committed it to memory, if I may, Madam President. So even though we may not have a federal state in Trinidad and Tobago, legislating predetermined ranges for spending at local levels and at the Parliament will give officers in those bodies the ability to engage in long-range planning, which will be down to the benefit of our nation. Madam President, under the leadership of Kamala Prasad-Bisesa, a proposal was being advanced to empower members of Parliament with a $10 million sum annually. I believe that proposal is very relevant today. It is very relevant today as we are speaking on the concept and on the principles of parliamentary autonomy and the devolution of powers of the state and the overall concept of fiscal federalism. And I believe this would be a move toward fiscal federalism. This measure would strengthen our democracy and improve the quality of representation at the level of the House of Representatives. Why do I say so? For example, electors in each constituency will see a direct link between their decision at the ballot and the services that their particular MP will be able to deliver. Whether or not that MP is in government in opposition or is an independent MP, Madam President. It would then make necessary the call for enactment of the right to recall. Because if you have an elected official who has access to the coffers of the state and they are not fulfilling their functions in the role that the people require, then the people should also have the right to recall them before their time is up within some constitutional arrangement. Now, Madam President, what does all of this mean? That is the ideal. The end result may not be the low-hanging fruit. So what we need to do today is recognize where we are at and take steps gradually, if not in haste, at least take gradual steps towards that eventual outcome, which would really make the electoral system meaningful to each and every citizen, especially the younger and more dynamic-oriented voters, who really are not necessarily in tune to the methods employed in the past, which really, I beg to submit, are steeped in a bygone era. We need to bring forward our system of democracy into the new age. What is best for Trinidad and Tobago should be what determines what actions we take. Now, I want to continue citing from this document from the South African Parliament in question that I cited earlier. The implicit thesis of this brief is that the process whereby Parliament is subject to the same process as government departments is inconsistent with its status as an independent arm of the state. In this regard, there are useful models which parliaments can draw from where parliaments exercise full autonomy over their financial allocations. So, Madam President, we are here, and in this House, we decide on law. We decide essentially what would be the framework or the ring fencing, as we like to say in some private sector organizations, for the public servants to do their work and the statutory and state bodies to function. We also provide a check and balance on the executive. However, it is not consistent for the executive to be determining the budget of the parliament on its own. It should be a system of collaboration. Yes, the executive is very important. They represent the party that would have received the mandate from the people. However, when it comes to systems of checks and balances, the parliament must be unfettered. So the paper continues to speak to parliamentary autonomy and financial independence. And that section begins by stating that the bedrock of parliamentary autonomy hinges on financial independence. Autonomy in this context is simply defined as non-dependence and non-subordination of parliaments in relation to the executive, a concept that I believe I just outlined. As such, parliaments, by constitutional arrangements, are supposed to have enough financial muscle to carry out their legislative mandate, including exercising power over their budget. Now, Madam President, the principle of autonomy in practice essentially looks at three areas: control over staffing, control over its own budget, and organization of its own business. Again, I remind persons of my initial reference to the old adage, who pays the piper calls the tune. It is not sufficient for Parliament to say that they are deciding their own staffing and that they are organizing its own business, when, in effect, they are not in control of its own budget. So therefore, it's only after its allocation has been given to it or granted by the executive, then they would now see how they can rationalize the order of business and the staffing requirements. This is an unacceptable situation. It's untenable. We know it is, and I appreciate that. That's why we are here having this discussion today. Now, Madam President, the last point I want to take from this paper, or second to last point, is the establishment of the all-important Budget Office. And I'm sure members of the independent bench would really appreciate this part of it. For example, if you're an independent senator, I don't have to go further, I'll only make reference to the presentation made by the leader of the independent bench, Dr. Marbury, where he looked at the coordinator of the independent bench. Sorry, yes, because they are independent. There is no lead. My apologies. So the coordinator of the independent bench, Dr. Marbury, when he... Yes. I'm being reminded by the head of government business, the Honorable Minister, that there is no head. So, Madam President, the Budget Office provides the technical support that will be essential in an objective manner. Now, again, that support can only be objective if the process for deciding who are the staff is an independent one and autonomous of all other arms of the state, and they are in control of their own budgetary situation, given the confines of the government revenue. Of course, that will be done in collaboration with the executive. So I would like to read this aspect and to put it on the Hansard, because they give some main functions of the Parliamentary Budgetary Office and as well a synopsis of it. So the legislator is in the process of establishing my apologies, Madam President. The establishment of a Parliamentary Budget Office will allow for the building of capacity for the members of Parliament on budgetary and economic issues. So in essence, it will strengthen the quality of all the contributions to matters of a financial nature. And the main functions of the Parliamentary Budgetary Office will include, and I believe there are 9 points. The first being providing economic forecasts that originate independently of the executive branch, interrogating underlying assumptions and attendant risk, making baseline estimates of revenues laws, as well as debt and structural deficit projections. The other, examination in detail. This point is very critical, Madam President, because one may have their own perspective on a critical issue, but to truly represent what we are doing here, to enlighten the public, to distill all angles of a story, and to really educate ourselves as peers, the examination in detail is important, and it underscores the need for highly technical and diverse staff in the employ of the Parliament. It continues, presentation of various options for the budget, including spending increases, tax cuts and increases, and suggested implications of broad policy choices. For example, we all know of the importance of tertiary education and tech voc training. If, for example, in a budget, you see a cut or an increase in a particular line item, the Parliamentary Budgetary Office should be able to objectively outline what will be the negative fallout and also the positive attributes of each fiscal measure and each line item of expenditure. So therefore, we can, as a country, rationalize what would be the necessary actions to remedy any fallout and what would be the actions to bolster any gains that may arise. The fifth point is scrutinizing proposals for new programs and costing of new legislation, as well as policy briefs for the new programs. I don't need to highlight how important it is to get pre-reading for any budget. Then monitoring and evaluation, oversight, and accountability. I believe this is the seventh point. Long-term financial sustainability analyses. Coming from the financial sector, economics, and business training and development, Madam President, I believe this aspect is important in Trinidad and Tobago. And I want to divert a little bit to bring this point, which is linked to parliamentary autonomy, which is long-range planning. Because in this society, we are a young nation, but our civilization in the Caribbean is centuries old. Our experiences run along those centuries. we may not have been in control of our system of governance for the majority of that time. But we can glean lessons from that. And we can understand that when the colonizers brought many of us here, they were engaging in long-range planning. Therefore, if we as a society are to punch above our weight as we claim we do, in the future, we need to engage in long-range planning. However, if the Parliament, Madam President, is confined to looking to see who will be in government, trying to determine how exactly their budget will be cut, examining the mood of the Minister of Finance to determine if he or she may slash aspects of their spending, then really what we are engaging in is reactionary planning. And that should never be the case going forward. We admit it has been a feature of our past, but that should not be the case going forward. Because really and truly, what is preventing our Parliament from planning for 50 years, for 150 years, to seeing where our society will be at that time?
Obika, you have 5 more minutes.
Thank you very much, Madam President. To see where our society will be at that time and trying to bring some level of common ground for all politicians, all stakeholders benefiting from the repository of information that we have in the JSCs and in the library, etc., so that we can really see how our civilization as a country can evolve for the benefit of the citizens of Trinidad and Tobago, the Caribbean region, and humanity as a whole. Because there may be some other societies, as the research has shown, there are many countries where the parliament is not autonomous, and therefore they are suffering, they may suffer from the same fate of the inability to engage in long-range planning, especially when the key officers, office holders, have to be concerned with their jobs each time there's an election or a change in a minister, etc. Now, once that can happen, Trinidad and Tobago can be a shining light on the role of the parliament and the electoral system in the world. The last 2 points that this document points to is the analysis of cost of regulations, for example, to the private sector. We debate many bills here. The finance bill, for example, will bring measures such as the changes to the rate on the green fund and the business levy. And when you look at the increases to those two taxes, if you may call them that, to the government, is the bottom line of a company where they may pay 30% of their profits. When you add the green fund and the business levy, they may pay as much as 45%. In some cases, 48% or 50%. It depends on their spread, and it depends on their net income ratio to sales. So it is important that, because, for example, if an independent or government or a senator on our side has the benefit of this expert opinion, which may provide a different view from what we already possess, we may be able to think twice on a measure or two. And the last point is the capacity building of legislative financial oversight. So, Madam President, as I wrap up, the points are: who pays the piper, calls the tune. We want the Parliament to determine its own by having autonomy, financial autonomy, have a parliamentary budgetary office, so that we can project and plan long in the future for the development of our society in Trinidad and Tobago. I thank you.
Minister of Agriculture, Land and Fisheries.
Thank you, Madam President, for the second time this afternoon. I rise to speak on the motion brought by Senator Mark relating to this issue of parliamentary autonomy. Madam President, I want to open by saying that I want to make 4 points on the motion itself. And the first thing I want to say is that the motion itself is rooted in an inaccurate record of the Joint Select Committee report of 2015. And it's vital that we understand that. The second thing I want to say is that the motion ignores several aspects of the Joint Select Committee's work, and those gaps ought to be dealt with. And the third point I want to make on the motion is that the motion omits reference to a series of activities and documents from the period 1997 to 2015, particularly the 2010-2015 period, which I believe are vital to the consideration of the matter of parliamentary autonomy. Ultimately, Madam President, I would close by submitting 4 things, which is to say that valuable ground has already been laid on the issue of parliamentary autonomy. It is vital that the Parliament completes the work set in train in 1997 and identified in the GSC's report of 2015. It is critical that in laying a bill before the Parliament, if it is determined that that's the way to go, that the bill represents the body of work that has been done, and the bill is truly capable of achieving the objective of parliamentary autonomy. And on my final submission, I would say, in my view, there is more work to be done. Let me go, Madam President, just quickly to say that the issue, the gap as I have identified in the motion, is the valuable work that has gone on from 1997 to 2015. And we were all provided, Madam President, with an information brief on the issue of parliamentary autonomy from May 2017. And that brief very concisely traces the period 1997 to 2015. And I feel that it's very important that we treat with that in dealing with the issue. And the brief sets out that in 1997, a report of the House Committee, as the first step, in 1997, a report of the House Committee of the House of Representatives identified a need for organizational change in the Parliament, having regard to the fact that the Parliament had remained relatively unaltered since 1962. Secondly, in 2000, a working paper of the Law Commission on the reform of the management structure of the Parliament was laid before both houses of Parliament. Thereafter, after deliberations, a joint select committee laid its report in 2000. Thereafter, Parliament adopted both the work of the Law Commission working paper and the recommendations of the Joint Select Committee, out of which the Parliamentary Service Act was produced, Parliamentary Service Act 2001 and the Constitution Amendment Act 2001 were produced. And we went through a period of inactivity following the dissolution of the Parliament in 2001. And thankfully, things picked back up, not in 2014 with the Parliamentary Service Authority Bill 2014 being laid, but there were some intervening activities that I would report on leading up to the laying of that bill. And when that bill was laid in 2014, a decision was taken to refer the bill to a Joint Select Committee of the Parliament. And that Joint Select Committee, I would also refer to the work of that Joint Select Committee. And as a final stage, in this term of the Parliament, the motion before us is what brings us to this discussion. So that from 1997 to 2001, there was some activity, including a Joint Select Committee report, a bill that was drafted, and 2 bills, in fact, one dealing specifically with changes to the Parliament, and more importantly, one dealing with an amendment required in the Constitution. And then when things picked back up, we had, most importantly, a bill being laid in 2015 and a Joint Select Committee report being tendered. Madam President, the motion refers in my first submission that I believe that the motion is rooted in an inaccurate report on the Joint Select Committee report of 2015. I just want to say, in terms of the work of the Joint Select Committee as reflected in the Joint Select Committee's report tendered at the 5th session of the 10th Parliament. And I want to go straight to the reference in the motion, because the motion says that the Joint Select Committee, whereas the Joint Select Committee agreed that parliamentary autonomy is essential to the recalibration of the existing relationship between the executive and the legislature. Well, the Joint Select Committee did not get to the point of agreement, and there were reasons why they did not get to the point of agreement. In the report of the Joint Select Committee, the Joint Select Committee, in the normal structure of a report, sets out the membership, the chairmanship of the committee, sets out the meetings and the work of the committee, and then goes into a section which is captioned Observations. And on page 4 of the report, under the rubric Observations, appears a subheading, Autonomy in Financial and Administrative Arrangements of Parliament. And the committee reports, and I would read it, and I quote, changes to the arrangements where executive branches oversee essential resource administration requirements. Arrangements are required for Parliament to fulfill its constitutional purpose. Practical considerations include the desirability of change, the detailed form of proposed changes, and the assumption of responsible stewardship to the part of Parliament for matters that were previously the responsibility of the executive government. So this was, Madam President, and I submit, this was an observation of the Joint Select Committee. It was not an agreement of the Joint Select Committee. It was an observation, but it was an important observation that requires our consideration, because the observation points out that for further consideration, you would need a number of things to take place, and you'd need to have a consideration of a number of things, including the detailed form of the proposed changes and the assumption of the responsible stewardship on the part of the Parliament for matters that were previously the responsibility of the executive government. So this is not merely an attempt to give the Parliament financial autonomy by giving it control over its own budget allocation and control over the spending. And this is not merely shifting the Parliament from the staffing arrangements in terms of allowing the Parliament the autonomy to staff the Parliament. There are more fundamental changes to take place regarding the separation of powers if we are to achieve the autonomy. And I think that the Joint Select Committee recognized, that there was further work to be done, that it was possible to achieve certain things, but it required, and the more fundamental changes which were required, there was more to be done, and it was not just the laying of the bill. And I suppose that that is why, Madam President, in the previous years, the attempts to move the issue of parliamentary autonomy either slow down or stop on account of having to confront some of the fundamental changes that were required. So my first submission is that we have to reflect correctly what were the observations of the Parliament, of the Joint Select Committee, and what were the agreements. And in relation to this issue of the recalibration, again, under the rubric parliamentary autonomy, in specific reference to that part of Senator Mark's motion, the committee reports as follows. Parliamentary autonomy should be viewed solely, Madam President. Parliamentary autonomy should be viewed not solely in terms of separation, but rather as a recalibration of the existing relationship between the executive and the legislature based on an underlying evolution in Parliament and state maturity. Basic requirements for parliamentary autonomy include the following, and then the report sets out some of the basic requirements for parliamentary autonomy. Again, not agreeing, but making an observation that these are the things that are required as we move towards parliamentary autonomy. And I say it's not merely the laying of a bill. And ultimately, on that JSC report, Madam President, on the final page, page 6, under the heading Recommendations, this is the recommendation. There was one recommendation of the committee, and I quote, "Your committee recommends that the Parliament take note of the progress made by the committee thus far, including the adoption of the policy on parliamentary autonomy. It is the hope of the committee that the matter of the financial and administrative autonomy of the Parliament will be considered in the 11th Parliament, and that the extensive work done to date and the preliminary report on the appropriate recommendations on parliamentary autonomy in Trinidad and Tobago would provide the foundation for the continuation of efforts to restructure the management of Parliament's administration." So the report, Madam President, the Joint Select Committee, chaired by my friend Senator Mark himself, actually acknowledged that we had come to a certain point in the discussion. The work that had gone before ought to be saved and carried forward. But it also recognized that this was not merely the laying of a bill, but this required a fulsome consideration by the Parliament of this issue of parliamentary autonomy. And Madam President, I want to make this point because I will now go into some of the documents that have supported this work. And I want to make one very important point, which runs through all the documentation on parliamentary autonomy, and which is something that it is not for the Parliament and parliamentarians to confront, but it is an issue for perhaps the Salaries Review Commission, and I've addressed that previously, but throughout the documentation. When you look, Madam President, at this week, for example, every week the Parliament publishes a schedule of event activities, parliamentary activities for the week. And when you look at this week events, for example, there are 7 committees of the Parliament sitting this week. And that points us to the key consideration in this issue of parliamentary autonomy, and that relates to the issue of, 1, the status of parliamentarians in terms of full-time and part-time. And that is something that is fundamental, but something that is not being addressed anywhere. But all the reports, before we talk about the bill, we must deal with the current situation where parliamentarians are required to divide their time between the sittings of the lower house or the upper house. In the case of ministers, in many cases, having to allocate time for both houses, and the case of all parliamentarians to allocate time across a series of joint select committees. And we see, Madam President, even in this session of the Parliament, we see not only the established committees in terms of the departmental committees and the joint select committees, but we also have JSCs on special pieces of legislation. So parliamentarians have found themselves having in this session to deal with the JSC on the anti-terrorism bill, JSC on cybercrime, and other pieces of legislation that have come up in this current session. So fundamentally, Madam President, in terms of priority, before we get to drafting a bill and before we get to the point of laying a bill, we have to confront the issue of the people who must stand in support of that bill. Because what this bill, what the latest version of the bill, which is the 2014 version, does, what the latest version does is that in addition to the responsibilities of a member of the lower house or a senator in this house, in addition to those responsibilities, a senator or a member in the form of a legislator standing here in debate, and in addition to the role of a legislator performing another function in a joint select committee or a select committee, the bill in the latest form calls for members to perform the work of operating the parliament by sitting on the board of the authority. So here we are proposing a third level of responsibility for parliamentarians without addressing the issue of hours of work and pay. And we know different from the daily paid workers who from time to time bargain and bring for us comparisons of workload and skills required and expertise and experience required. And I'm not here campaigning for a raise. I'm not doing that. I'm just saying that the issue of full-time or part-time status of parliamentarians must be addressed as a precursor to moving this issue of parliamentary autonomy along the line. And we have to confront that. I want to refer, Madam President, to this February 2012 report, which came out of an European Union-funded study. And the report is titled, Activities on Strengthening Parliamentary Practices in Trinidad and Tobago. And the report is 70 pages long, and it makes for a good reading. But I just want to go to page 7 of the report and deal with a finding of the report, and I will quote from page 7, which says, the problem facing Trinidad and Tobago is similar to an issue facing many small country parliaments. The membership of parliament is not large enough to support multiple committees, and the number of members who sit on the committees is limited. One option is for a mandatory minimum membership of backbenchers and executive members. Another option would be to make use of non-members in the work of the committees, something which is used in other jurisdictions. And thereafter it goes on to say, current attendance levels are quite high, but the number of meetings is low, with some meetings cancelled because of quorum. The current practice is to set quorum at 5 members with rules ensuring government opposition and House Senate attendance. Strict and prescriptive rules can prevent business from being transacted or lead to the proceedings of a committee being suspended at any time. A quorum of 3 members could alleviate the situation. And that is the reality, Madam President. In addition to members of Parliament in both houses having to double and triple up and so on and find themselves on multiple committees, the Parliament has found itself in a challenge at this time, because when you have a sitting of the lower or this house, you cannot schedule, obviously, you cannot schedule your joint select committees, your committees, or your other committees of the Parliament. You can't do that. When you have cabinet, you can't select, you can't schedule on those days, so that you are limited to certain sections of the week when you can schedule. And when you do schedule, you have members on multiple committees with competing schedules, and you have ministers who serve on committees who themselves may have schedules, and we run into problems either when we all agree on a date when everybody could be there of having a high attendance, or those periods when we cannot get a quorum, and we therefore have little or no attendance. And if we're talking about parliamentary, what the reports are saying to us, it is not merely having a system of joint select committees. Madam President, I'm on record here and elsewhere of saying, based on my experience and my observations of parliaments across the country, particularly parliaments of our size, this parliament must be the most efficient and the most active parliaments of all parliaments I have seen and have been exposed to. And I've said it also, that perhaps the most vital contribution we make in this parliament is in the work that we do in the joint select committees, whether it is the joint select committees dealing with legislation, whether it's the joint select committee dealing with the departmental work, or the standing joint select committees dealing with specialized work. This is the work, this is the vital work. And if those committees are not constituted arbitrarily, I imagine that when the two houses and the leaders put forward the membership to the joint select committees, they make that based on a particular level of competence or a particular expertise that ought to reside on the committee. And if we have problems of not being able to attend the committee meetings, if we have problems because of clashes and because of workload, then the quality of the committee, not only the quantity in terms of how often the committee meets, but the quality of the committee's work suffers on account of not having the expertise available at the committees. And those are important considerations when we consider parliamentary autonomy, that it is not just the power to do the work, as we do in fact have, subject to weaknesses that I point out from time to time, but the mere ability to schedule, participate, and contribute to the work is placed in a problem by not having an appropriate definition of the nature of our tenure and service and the compensation that goes with it. I must refer, Madam President, to another report that formed part of previous deliberations on this issue. And I wanted to refer to it in support of what I've said, that we have reached a particular point and the quality of this parliament is not deficient on account of the lack of the financial autonomy or not on account of the staffing. That there is a standard in the parliament that has been recognized by the reviews that have been done. And that is what I say, what I mean when I say the motion ought not to start with the 2014 bill, but must recognize the work that went into in the previous years and what those reports have been saying to us. And I will quote from this report, Madam President, Report on Oversight to the Parliament of Trinidad and Tobago. And it was work commissioned and conducted by McGill University. And the report examines parliamentary oversight in Trinidad and Tobago and questions why it appears not to be working as well as in other countries around the world. And the report addressed five main areas, and one was oversight. And in dealing with the issue of oversight, the report found that the parliamentary committees exist and they function to provide the oversight that is required. In terms of the structure of the parliament and the structure of the reporting and so on, the report found that it meets comparable jurisdictions. In terms of composition, they found conformity in terms of composition of the committees. But in terms of the issues of power of the parliamentary committees and access to the public and access to information, the report found that we were in need of some strengthening in those areas. And in relation to the oversight committees, I just want to report from place on the record what the report says at page 14, and it says, in short, Trinidad and Tobago's oversight committees would seem to have stronger powers and greater access than oversight committees elsewhere, both globally and in the Caribbean. But again, it is necessary to look elsewhere to determine why committee oversight is weaker in Trinidad and Tobago. So while we may have the committees and we may seem to have stronger committees and stronger powers in some cases, there are still weaknesses, and the report goes on to identify some of the weaknesses, and essentially it has to do with frequency of meetings, the attendance at the meetings, and the gaps between meetings, which sometimes weaken the work of the committees. And at page 18, the report says, what factors determine committee productivity based on the number of reports issued? And it says, one factor is the number of staff supporting the committee. But here in Trinidad and Tobago, committees are relatively well served. So the committees are well served. Another factor may be that committee members in Trinidad and Tobago, in contrast to most parliaments around the world, are part-time. And the number of meetings and inquiries they hold takes so much of their time, they simply do not have the time to produce the reports. So it's not just the number of meetings and the frequency of meetings. Even after you find that you have met, the issue of producing the reports seem to be an area where there is deficiency. And on page 19, the report confronts the issue of full-time versus part-time parliaments, and it says, there has been no global research on possible disadvantages and advantages of part-time versus full-time parliaments. Trinidad and Tobago has one of the few national parliaments in the world whose members are not full-time. And that, as I said, is an important consideration, that we have to consider this issue of full-time and part-time. Madam President, in the period in 2013, the Parliament itself commissioned a strategic plan, the development of a strategic plan for the Parliament of the Republic of Trinidad and Tobago 2013 to 2018. And that plan set out several objectives for the Parliament of Trinidad and Tobago. And there were principally 4 objectives. And I will just quickly go through the 4 objectives. First, it was to increase the institutional capacity of the Parliament in general and the Secretariat of the Parliament specifically, to improve the legislative process in Parliament to ensure enhanced scrutiny and quality of legislation, to improve the capacity of Parliament to provide effective oversight, and fourthly, to develop the outreach work of Parliament and to strengthen the representative role of MPs. Madam President, wherever you see objectives and recommendations, wherever you see a report attempting to deal with the issue of strengthening, increasing access, improving, it falls to the parliamentarians to do that. It does not fall to a different arrangement. It is the parliamentarians who are doing the additional things that are required to make our parliament more vibrant and more vital. And as I said, it comes down to the ability of our parliamentarians to contribute the amount of hours required and the quality of work that is required. Madam President, on those 4 objectives, the issue of the increase of the institutional capacity of Parliament in general and the Secretariat specifically, I want to say that that issue is at the root of parliamentary autonomy. While we may focus on the budgetary and the financial independence and the ability to control the budgets, what we have all found as parliamentarians, we found 2 areas that make us strong or make us weak. And what has we found that has made us strong, and what in both houses I hear parliamentarians referring to, is the quality of the staff and support in the Parliament. And that, Madam President, if there's one thing that must be addressed, whether it's by a bill or parliamentary autonomy or whatever, is the preservation of that specialized capacity that this Parliament, I don't know how, develops, particularly using our graduates from the University of the West Indies. It must be some magic that takes place. It's like a magical kingdom, that something happens in this environment, Madam President, that lifts and develops the quality and the skills and the capacity of our local university graduates to support us. But one of the issues, of course, that we find ourselves dealing with in the public sector is the fact that having reached to a certain skill level and having developed a certain capacity, there is no room for upward mobility in organizations, and the Parliament may be such a place. So that while we are very good at developing the talent and developing the capacity, the structure of the Parliament must reflect the opportunity for upward mobility and growth of the professionals who work here. And that is something that is vital to parliamentary autonomy, because if we are going to take the Parliament through the long term, part of it has to rely on the continuity of the staff, because even as we propose, even as we considered in 2014 the Parliamentary Autonomy Bill, one of the issues, Section 30, Clause 13 of that bill, dealt with the board for the authority, the Parliament's authority that will run the Parliament. And being staffed by members of Parliament, the issue of continuity arises. And that is one of the weaknesses of that bill. The strength of the Parliament is based on continuity. And if we don't have the continuity amongst the parliamentarians, because certainly as senators, as I always say, I'm a daily paid worker. I know I will get paid for today because I'm at work, but I'm not sure about tomorrow. And the continuity is a factor in this House in particular. This House in particular. In the other place, you may have certain inbuilt protections, but here you are at the mercy. Well, so that behest. At the behest, sorry, I used the wrong word. May I correct myself? At the behest. So the issue of the quality of staff, the permanence of the staff, the independence of the staff, and the preservation of the institutional knowledge of the staff are vital issues in relation to autonomy. And whether we go by bill or by JSCs or whatever, it is a subject that as a parliament we ought to address frontally and suggest to the executive the ways in which that can be achieved. Because, Madam President, I could assure you it is not easy. It is not easy to effect that. We've tried it, for example, in carving out public service functions and placing it in the hands of state enterprises. And if we use the RHA for an example, at one time it was thought that that's a model, that we create the RHAs and put them, give them geographic responsibility, and all will be well in health care. Thank you, Madam President. But as we found out that the RHAs all have to go to the Ministry of Health for funding and for policy direction and for a variety of things, so that it really never got full autonomy, particularly financial autonomy and the ability to run their affairs. So that we want to make sure that whatever we do it conscious of the fact that the staffing forms a vital part to the success of our Parliament. The other report I want to refer to, Madam President, as I close, is this, the latest of them all. It's a report called Transformation for Accountability, a forward-looking review, interesting expression, of the 10th Parliament of Trinidad and Tobago 2010 to 2015, produced by the Office of the Parliament, dated June 10, 2015. And basically, this report examined the work towards the 4 strategic objectives set out in the strategic plan. It looked at a number of issues that arose in the consideration of the autonomy and also addressed the way forward. And Madam President, among the many things in this report, and it is a very valuable report that I think all parliamentarians should read, in terms of the work of the Parliament. And I don't know the experience of other members, but I want to say in my own experience, I have found that these questions that are asked, whether it's question on notice and urgent questions and Prime Minister's questions, form a vital part of the work of the Parliament. And you don't need parliamentary autonomy to recognize that. That is a vital part because it is an important tenet of the functions of a Parliament to ask questions and demand accountability of public office holders. And this report on page 29 traces the use of questions and points to, and one Senator Mark is here, I'm not surprised about this, points to the increased numbers of questions. I don't know how you made out, Senator Mark, when you were on the seat in the other place. There may have been a decrease. But points to the greater number of questions and the higher percentage of answers provided over a period of time, and it breaks down all the categories to demonstrate that there's been increasing not only the filing and the use of questions, but an increase in the percentage of responses to the question, and that is a vital part of democracy. So I want to close, Madam President, by saying I'm not here to criticize, but I'm here to make some comments about the motion itself. And I want to propose, Madam President, an amendment to the motion, if I may be allowed to do that. And we propose, Madam President, that the motion be amended to read as follows. Be it resolved that the Senate call on the government to introduce legislation to give effect to parliamentary autonomy during the 11th Parliament. In other words, Madam President, we support it. We want to see what the Joint Select Committee of 2015, where they reached. They made observations. We have all these reports that are available to us, and we find it difficult to be confined to a date and to a particular bill. And what we are asking is that the government be allowed the opportunity to introduce legislation to give effect to autonomy during this 11th Parliament. I thank you very much.
Honourable Senators, the question is, this amendment is being posed, so well, yes. The amendment, as proposed by the Minister, is for the motion to read as follows. Be it resolved, just 1 second. Be it resolved that the Senate call on the government to introduce legislation to give effect to parliamentary autonomy in the 11th Parliament. There needs to be someone to second that amendment.
The amendment is so seconded.
Honourable Senators, let me go it over again for the records properly. the amendment that is being proposed by the Minister is as follows: to delete the last paragraph of the motion and substitute the following: be it resolved that this Senate call on the government to give effect, to introduce legislation to give effect to parliamentary autonomy in the 11th Parliament. Now, to give effect to parliamentary autonomy, the word that was presented is in the 11th. During the 11th Parliament? Thank you. And I now need someone to second that amendment.
I beg to second.
Honourable Senators, the amendment to the motion has been seconded by the Minister of Trade and Industry. And Senators now taking part in the debate can speak on the original motion and the proposed amendment. Senator Ramdi.
Thank you, Madam President. And it is indeed a privilege to join this debate on a private motion brought by Senator Mark in the following terms: whereas financial and administrative autonomy of the Parliament is an undisputed benchmark of a true democracy, and whereas a legislative proposal entitled the Houses of Parliament Service Authority Bill 2014 was laid in the Parliament and referred to a Joint Select Committee in 2014, and whereas the Joint Select Committee agreed that parliamentary autonomy is essential to the recalibration of the existing relationship between the executive and the legislature, and whereas the government, in adopting the 2015 Manifesto of the People's National Movement as its official policy framework, confirmed its commitment to the principles of parliamentary autonomy. Be it resolved that the Senate call upon the government to introduce legislation by April 30, 2018 to give effect to parliamentary autonomy, and that this legislation be immediately referred to a Joint Select Committee of the Parliament for early consideration and report. And the amended motion, as seconded, seems to extend that period of time, or seeks to extend that period of time to the life of the 11th Parliament. Madam President, it is not surprising that the motion brought by Senator Mark is one that calls for parliamentary autonomy, a principle which has been recognized throughout the Commonwealth as a pillar that strengthens the democracy of any country. And in the Minister of Agriculture's contribution, he made specific reference to the fact that perhaps the most significant work that is done by the Parliament is done by the Joint Select Committees of the Parliament. I would have thought that my friend, the Minister of Agriculture, would have made reference to the fact that Section 66A of the Constitution, which provides for the appointment of certain select or joint select committees of Parliament, was a provision that was inserted into the Constitution by a United National Congress regime. It is only because of that amendment by Act 29 of 1999 that we are able today to have the kind of accountability and the calling to account of government ministries, municipal corporations, statutory authorities, enterprises owned or controlled by or on behalf of the state, or which receive funding from the state of more than 2/3 of its total income in any year, and service commissions are able to be brought before the Joint Select Committees of Parliament. And as the Minister of Agriculture has said, it is perhaps the most significant work that is done by the Parliament. So it is no surprise that Senator Mark has brought this motion. The history of the United National Congress has always been such that we have piloted the most significant pieces of legislation that have upheld the democracy in this country, whether it be the Equal Opportunities legislation, the Judicial Review Act, the Freedom of Information Act. The list goes on. the integrity in public life, the democracy of Trinidad and Tobago has been strengthened by the work of the United National Congress when in government. But having listened to the many contributions that have been made to this particular debate, Madam President, I think that it is an apt opportunity for us to recognize in the manner in which the government has responded to this motion for parliamentary autonomy and for the Senate to call upon the government to lay legislation in support of parliamentary autonomy. For us as a parliament, as a Senate, and for the country to recognize the hypocrisy of the PNM when in government. And I'll demonstrate why I say that on a matter that ought not to be very controversial. We have sat in this parliament, in this parliamentary term, for the last 30 months. And pieces of legislation, one after the next, have been brought by the government. And perhaps the three most popular words that have been used by the government in answer to calls for a joint select committee by the opposition, by the Attorney General, no less a person, has been analysis paralysis and proportionality. So when it suits the government, it's analysis paralysis to go to a joint select committee. But when one calls for parliamentary autonomy and for the laying of legislation that will strengthen the democracy, it is paralysis analysis on the part of the government. So one more time, and we've sat here and listened to the Attorney General tell us we must talk more and we must consult more when they're in government, when it's convenient to the government. But I think that a greater message is sent by that type of behavior, Madam President. I think it demonstrates that the government is preparing to come into opposition and the opposition is preparing to go into government. Because it doesn't go without passing or unnoticed that for 30 months, what this government has done is regurgitate legislation that had been brought to the Parliament between the period 2010 and 2015. The preliminary inquiry bill, trial by judge alone, land title, motor vehicle and road traffic, plea discussion and plea agreement. These were all pieces of legislation that were lying in the Office of the Attorney General that was drafted between the period 2010 and 2015. And for the last 30 months, what we have gone through is an exercise of regurgitation of UNC legislation under our PNM administration. So I don't see why the government is now taking the position that we must consult more and talk more and do more work. I have sat here in this parliament and listened to members of the Senate say they are prepared. No bill is perfect. They are prepared to have a piece of legislation that gets it 75% correct. And they are prepared to support that kind of legislation. Well, Madam President, we have a piece of legislation that supports parliamentary autonomy. It was laid in, as a bill sent to a Joint Select Committee, the Houses of Parliament Service Authority Bill 2014. And I don't understand why the government doesn't want to continue with the way in which it has been governing for the past 30 months and just regurgitate it, bring it to the Parliament and let's pass it. That has been their modus operandi for the last 30 months. I don't see that it's going to change in the next 20 that they're going to be there for. So I don't see there's any reason why we need to have more analysis paralysis and more talking. I think we should bring this bill immediately. I don't think that there's any need for us to continue this consultation and this more work attitude. This government is not doing any more work. Let us just do and copy what the UNC has done and bring it to Parliament and claim victory for it. So this is quite an important piece of legislation, Madam President. And it's quite an important piece of legislation because it is built upon a principle that is supposed to be a pillar of our democracy, parliamentary autonomy. You see, Madam President, we function in a democracy that is based on a written constitution. And when one examines the written constitution, it is very clear that our evolutionary style of Westminster model that was given to us and transplanted to us, to use the words of a famous constitutional writer, provides for an independent parliament in Chapter 4 from sections 39 to sections 66D. And I would want to submit, Madam President, that as was said by the Privy Council back in 1977 in Hinds and the Queen, when Lord Diplock described the Westminster model constitutions as having been drafted based on a separation of powers, the motion and what Senator Mark calls for in the motion and what is represented by the House of Parliament Service Authority Bill is simply one further step in the direction or in the path of recognizing that the Parliament, by virtue of the expressed way in which our Constitution is drafted, ought really to be autonomous from the other arms of government. And much material has been produced throughout the Commonwealth about the origins of parliamentary autonomy, the benefits of parliamentary autonomy. And, Madam President, the one organization that has done a considerable amount of work that has been relied on by the Parliament in order to reach the point that we have reached is the Commonwealth Parliamentary Association. And I think a great debt is owed to that organization by all the Commonwealth countries that have benefited from the considerable amount of work that that organization has done to strengthen and call for Parliament, not only parliamentary autonomy, the recognition of human rights and the strengthening of the rule of law in constitutional democracies throughout the Commonwealth. And in one of the papers that was presented by the Commonwealth Parliamentary Association on the Latimer House Principles on the three branches of government, it was recognized that the independence of parliamentarians and Parliament itself finds its genesis in Article 9 of the Bill of Rights 1688, which provides that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. That was the origins of the idea of an independent Parliament and what we know today as the Parliament that finds its rooting in our written Constitution. But, Madam President, one has to wonder why a government would not want to embark immediately and support legislation that calls for parliamentary autonomy, when the only aim or the principal aim that is to be achieved by the passage of any legislation in this direction is to strengthen our democracy, uphold the rule of law, and support the hallowed principles of the separation of powers. And I would like to refer to certain pieces of learning, the first of which is a report that was done by the World Bank Institute, headed the Administration and Financing of Parliament, a study group report published by the Commonwealth Parliamentary Association. And in 2005, I wish to quote from what that report said on the financing and administration of Parliament, dealing with the autonomous nature and the support for parliamentary autonomy. And if I can quote, Madam President, it says, "In cases where such bodies have been established, referring to the autonomous nature of Parliament, in cases where such bodies have been established, there is evidence that Parliament is better able to assert its independence and ensure that adequate resources, both financial and otherwise, are made available. This in turn enables Parliament to discharge its functions more effectively, while also allowing members to exercise appropriate control over the prioritization of the delivery of services by the parliamentary service. And that brings me to a very important point, Madam President, which relates to something that has been said both by the members of the independent bench and my fellow senators on the opposition bench, which is the tabling of the work of the Parliament. And what you find, as we have found during the past 2 years and 6 months, is that we start each parliamentary session with a very slow turning of the wheel by the Parliament. And then when time passes and it seems to be recognized that the Parliament is not working at the pace it should work, then the whip is cracked and we are asked to be here 2 and 3 times for the week. And that cannot be. And you see, that is only because the timetable of the Parliament is controlled by the administration that is in power, because they control the legislative agenda, not only in terms of the subject matter, but they control the legislative agenda in terms of how quickly the wheels of the legislative machinery of the Parliament will turn. So, as this government has demonstrated time and time again, during September to January, February, March, it really is a slow pull for the Parliament. But when we come to April, May, and June, and the whip is cracked, what you have is a situation where the government has little or absolutely no consideration for the work that has to be done by all of the members of Parliament. And therefore, we are given these unreasonable demands that we are asked to meet. And I don't think that that is the way it ought properly to be done, Madam President. If we had an autonomous Parliament, we would have a fixed timetable of when the Parliament sits, and the government will have to fit in to that fixed timetable the agenda, the legislative agenda that they wish to pass. And there is no one on the opposition or the independent bench that complains about the amount of work that has to be done. But what an autonomous Parliament would do is to provide efficiency into that system. And it will cause the system to be better managed, and the parliamentary work will be done in an extremely more efficient manner. Now, in that said report by the Commonwealth Parliamentary Association, particular attention was given to the issue of the accountability and ensuring the effectiveness and independence of the Parliament. And I want to again quote what the report says. Given that one of the key purposes of Parliament is to hold the executive to account, there is a compelling argument that Parliament should be able to discharge its constitutional responsibilities free from government interference. The drive for independence should not be seen as an aggressive one, but a necessary prerequisite to good parliamentary governance. Also, operational autonomy should not act as a barrier to the fostering of good relations with the executive, which is essential if legislation and public sector policies are to be fit for purpose. Madam President, these reports that have been produced time and time again by the Commonwealth Parliamentary Association have been acted upon by many different countries that comprise the Commonwealth of Nations. And it is a recognition that it has become, as the separation of powers has developed, to be an essential feature of every Westminster model-style constitution. And the separation of powers is now recognized to be a pillar of parliamentary democracy. So too, an autonomous parliament has become as recognized throughout the Commonwealth as being a fundamental pillar to an effective democracy that recognizes the rule of law and the protection of human rights. Independence in a parliamentary context is provided for at 3 levels, it is said: institutional, financial, and administrative autonomy. In countries that have written constitutions, the principle of parliamentary independence is often institutionalized in these foundation documents. And that is why I referred, Madam President, to the fact that we have a written constitution that recognizes the Parliament as an independent and autonomous institution. However, where no written constitution exists, institutional autonomy and the separation of powers can be established, as in the case of the United Kingdom. Financial control may rest with the Parliament or the executive, or there can be a collaborative model where Parliament determines the budget in consultation with the executive, where Parliament does not have financial independence. And this is to note, Madam President, where Parliament does not have financial independence, there is always the danger that the executive will be encouraged to exercise undue control over expenditure to the detriment of the parliamentary process. And I think that strikes at the heart of what Senator Mark is seeking to pillar and to promote in promoting this motion, to get rid of the idea that the government can hold a noose around the neck of the legislature and control the parliament in that way. It is clearly not a tenet of a properly working democracy. But that deals with the financial autonomy and financial independence. Administrative autonomy is about self-determination with regard to the nature and the level of services to be provided to the Parliament. The experience of the United Kingdom and other Commonwealth countries support the view that administrative independence and accountability is best achieved through the establishment of parliamentary corporate bodies. This has been reinforced by a number of independent reviews of the effectiveness of governance structures in parliamentary settings. In 1998, if we want to use an example, the United Kingdom government, as part of its devolution policy, established corporate bodies in the Scottish Parliament and the Northern Ireland Assembly. And it is very interesting, Madam President, because one of these reports actually takes us through a number of the jurisdictions that comprise the Parliament, and with reference to Australia, New Zealand, Fiji, India, Malawi, Uganda, Zimbabwe, and South Africa. The report makes specific reference to the fact that all of these Commonwealth nations have moved towards parliamentary autonomy. And we too, during the period 2010 and 2015, Madam President, moved towards parliamentary autonomy with the laying of the Houses of Parliament Service Authority Bill 2014, again without apology, by UNC administration. And when one looks at that bill, Madam President, which forms a significant part of the motion, and why I would make the submission that we should have no more analysis paralysis, it's because if one looks at the provisions that were set out in that bill, and one were to go to Clause 5, the objects of that bill are set out to be in that act: A, to ensure the autonomy of and to promote the efficiency of the Parliament of Trinidad and Tobago as established by the Constitution; B, for the purposes described in A, to establish an independent, non-partisan parliamentary service authority which shall be managed by a board for the purpose of exercising and performing such duties as are conferred upon it by this Act or any other written law, and that is efficient and effective in serving the needs of the Parliament of the Republic of Trinidad and Tobago. C, to provide a legal framework for the effective and fair employment, management, and leadership of the employees of the authority. D, to establish rights and obligations of the employees of the authority. And those are the objects of the authority that was supposed to be that was created by the provisions of that Act. Now, I would like to join the Minister of Agriculture, Senator Rambrad, in agreeing with him. Madam President, I think that the members of staff of the Parliament are clearly the most efficient and productive members of the public service. And I think as members of Parliament, this Parliament, whether it be here in the Senate or in the lower house, is really only able to achieve the work and the work product of the Parliament in the time that it has been able to achieve it, significantly and principally because of the hard work of the staff of the Parliament of Trinidad and Tobago. And Madam President, I don't know, like Senator Rambrat has asked, what is it about the work ethic? What is it about the parliamentary staff that allows them to be so committed and dedicated to their task? You can call the parliamentary staff, Madam President, at 6 o'clock in the morning, at 8, 9 o'clock at night, and you will get a response. It is unlike anything that is known of in the public sector. And if the public sector were to take an example of the members of staff of the Parliament of Trinidad and Tobago, Trinidad and Tobago as a country will be clearly much better off than the position it finds itself in today. Now, Madam President, I made reference to the objects of the authority, but the Houses of Parliament Services Authority Bill also provided for the membership of the board by virtue of Clause 13, and specific provision was made for the way in which the Parliament was to be financed, the financial autonomy that Senator Mark spoke of in piloting this motion. And if you would allow me, Madam President, by Clause 39 of that bill, under Part 6 of that bill, financial provisions, establishment of the Houses of Parliament Services Authority Fund. By Clause 39 of that bill, there was to be established a fund to be known as the Houses of Parliament Services Authority Fund. And there shall be paid into that fund, by virtue of subclause 2, such monies as may from time to time be provided by Parliament. B, such monies as may be borrowed by the authority on such terms and for such purposes as the clerk, in consultation with the board, may determine. And C, any monies accruing to or received by the authority from any other source. Subclause 3 provided there shall be paid out of the fund all payments in respect of any expenses incurred in pursuance of the provisions of this Act, which provides for the working of the Parliament. And subclause 4, the authority may, with the approval of the Parliament, signified by resolution, establish such other funds as may be deemed necessary. Now, my learned friend, Senator Rambrat, the Minister of Agriculture, made reference to the staffing issue. And I just wish to, in reply to that, point out that by Part 7 of the Houses of Parliament Services Authority Bill 2014, Clause 43, under the subheading of Staffing of the Authority, the manner in which the authority may employ staff and staff the Parliament is provided by subclause 43, 1, 2, and 3, which provides that the authority may employ on such terms and conditions as it thinks fit in accordance with the provisions of this Act, such staff as it considers necessary for the due efficient and economical discharge of its functions and exercise of its powers under the Act, and for such purposes shall establish a classification and compensation scheme. The employees of the authority shall be paid such remuneration and allowances and shall be employed on such terms and conditions as may from time to time be decided by the Clerk of the House, subject to the approval of the Board. And the Board must ensure that the remuneration, allowances, benefits, and terms and conditions of employees of the authority are comparable to those of public officers who perform similar duties. And what that does, Madam President, is to put into law, by virtue of this bill, if it is passed, if it is laid, or if it is pursued by the government, the statutory underpinning to allow for the administrative autonomy of the Parliament. And Madam President, this is a matter that the government, in my respectful submission, should not treat lightly. The functioning of the Parliament in an effective and efficient manner is the hallmark of any proper function in democracy. And if the government is serious and the government wishes to strengthen our democracy, to uphold the rule of law, and to recognize the pillars of our independence, then with haste, the government should lay this bill and let it have the consideration of the Parliament. But the amendment that has been proposed by Senator Rambrat, the Honourable Minister of Agriculture, seems to take the timeline to the end of this government's term. There's not much time left, and I don't know if it will allow for the government to complete what this amendment by Senator Rambrat seeks to do. Because, Madam President, any administration that controls the corridors of power in our democracy ought to do all that it can within its power to ensure that the Parliament remains independent and untainted by any actions of the executive. The Constitution and the laws that we make pursuant to Section 54 of the Constitution should ensure that the Parliament remains independent, and any opportunity that there is for the executive to exercise any kind of control, financial, administrative, or otherwise, on the Parliament should be something that any administration in power should seek to get rid of. You see, Madam President, while we applaud the fact that the Joint Select Committees of Parliament have made a significant inroad in terms of ensuring accountability, transparency, and good governance throughout the public service, the public sector, and the special purpose state enterprises that are set up by the government, what we must also understand is that because of the makeup and the composition of most of these Joint Select Committees, there is the ability of the executive to exercise a certain degree of control over what is done by the Joint Select Committees and the resources that are devoted to the Joint Select Committees in carrying out their mandate. And the Joint Select Committee on National Security is a perfect example of that. One would have thought that by now, having made a promise to the opposition when the opposition met with the government some year and number of months ago, that Joint Select Committee was so important to the safety and security of our country and the discharge of perhaps the most important responsibility and holding accountable the ministry that is responsible for the safety and security of each and every citizen of this country would have by now been headed by an independent senator. But that is not the case. The government has broken that promise, and pursuant to the recital in the motion that has been brought by Senator Mark, I think that the promise of parliamentary autonomy is going to be another one added to the list of broken PNM manifesto promises that this country has come to expect. It is just going to join the winding, unending list of a border protection agency that today might have been able to assist in relation to the migrant problem that we face, that has been the subject of so many questions and so many adverse comments by the United Nations Human Rights Committee. When one looks at the Guardian headline today, the chairman of Amnesty International, Latin America, criticized the government. And if the Parliament had the autonomy that it ought to have, it may well be that many of these difficult issues that we are grappling with today as a country may have found itself before a Joint Select Committee, and the accountability and governance that we expect could have been extracted from the executive. But, Madam President, it is clear by the words of those who have contributed from the government that this government is not serious about strengthening the democracy. It can't be serious about strengthening democracy. That will be adverse to its style of governance. So one can expect that parliamentary autonomy is just going to go down the hatch. Now, my learned colleague, Senator Obika, referred to a paper delivered in South Africa by the Honorable Lindewi Maseko during 15 to 19 September 2013 under the heading Financial Independence as a Means Towards Effective Oversight. And a very, very distinguished paper was presented, Madam President. And I just wish to quote, so that we can be brought home to the government, how important the issue of parliamentary autonomy and financial independence is. And it says the bedrock of parliamentary autonomy hinges on financial independence. Autonomy in this context is simply defined as non-dependence and non-subordination of parliaments in relation to the executive. This non-dependence and non-subordination, as stated above, is in terms of unfettered control over financial and other related resources. Therefore, according to the Latimer House Principles, this means that parliaments should have equitable access to resources. As such, parliaments by constitutional arrangements are supposed to have enough financial muscle to carry out their legislative mandate, including exercising...
Senator Ramdeen, you have 5 more minutes.
Thank you, Madam President. As such, parliaments by constitutional arrangements are supposed to have enough financial muscle to carry out their legislative mandate, including exercising power over the budget. This is consistent with the Latimer Principles that state that parliaments should have control of and authority to determine and secure their budgetary requirements, unconstrained by the executive, save for budgetary constraints dictated by national circumstances. In fact, this suggests that parliaments should assert their role as a separate arm of government. This includes the fact that they should be independent from the executive in the way they organize themselves, control over their timetable, and the ability to recall themselves outside normal session if circumstances so require. Madam President, when one looks at the way in which the ministries of government operate, and one looks at the way in which the Parliament operates, the way in which the Parliament discharges its function as a working arm of government, if there was one arm of government, one public authority, one ministry that has demonstrated that it is entitled to have autonomy over its affairs, it is the Parliament of Trinidad and Tobago. The Parliament of Trinidad and Tobago has demonstrated by the discharge of its functions, by the manner in which its staff is dedicated and committed to its role, and by its work product, that it is entitled to have parliamentary autonomy. With the limited resources that are devoted to the Parliament has really shown us how to get more from less. The rule of law, the separation of powers, and a hard-working democracy requires that there be parliamentary autonomy. Let us borrow the words of the Attorney General. Let us have no more analysis paralysis. There is a bill, let that bill be laid. Let us show. The government doesn't have much to show in 30 months. After 5 years, you all are not going to have much to show either. Grab the opportunity that you have to piggyback off some UNC legislation and at least do something for the people of Trinidad and Tobago and lay this bill as supported by the motion. I thank you, Madam President.
Mr. Roach.
Thank you. Madam President, I thank you for the opportunity to make a brief contribution to a very important, enlightening motion moved by Senator Wade Mark. And I must say that on this occasion, having listened on the last 2 occasions, I think this is our second opportunity of dealing with this motion. Or the third time. I think Senator Danny should have misled me. the third occasion. And from what I have heard, this has to be one of the most non-contentious debate that has taken place in these chambers thus far. Because from all the speakers, all the senators on either side of the chambers, all of us join in the importance of having a parliament that is independent of its affairs, both financially and administratively speaking. And to me, the only issue really to be determined from this motion is how soon this ought to become a reality. That is it in the crux. How soon? If it is, and I have spoken with Senator Wade Mark during the course of the break on his motion, and the time frame which was originally set to be the 30th of April 2018. He's quite willing and mindful of the short time in which this to be done, notwithstanding the fact, as Senator Ramdin has just said, there's a bill in existence that has been massaged and has been debated elsewhere, and that probably little need to be done in order to bring it before us, to have it debated and probably, hopefully, implemented within the life of this Parliament. Now, I'm not sure if an undertaking can be given by the government that should the amendment proposed by the Honourable Minister Clarence Rambarat be acceded to, that it be done within the duration of the 11th Parliament, if that can be held to that. Certainly, I think it is something to consider in moving forward this, because as Amin has been here all the time, we don't want to be debating and re-debating something that has basically been already properly, I think, fleshed out in both houses. The importance of parliamentary independence, autonomy, for the listening public that may have been probably be wondering at this point in time, what is all this fuss about being made in 3 sittings on a private motion to deal with an issue of Parliament that is in existence? And clearly, just to bring it back to focus, one of the critical functions of Parliament, it is in the scrutinizing of government's activities. It also, one of the main functions of it is also the Parliament serve to give consideration and look after the affairs of the voters and the citizens of the country who would have elected and in some instances appointed us to be here. And one of the most critical functions of Parliament is in passing laws, their legislative functions. And last but not least, is the passing of the budget, national budget, which supervises and which caters for government provision of goods and services and how the economy will eventually unfold for the welfare, for the benefit of its citizenry. And any one of those items by itself could give credence why Parliament should be independent, should be given its independence. I mean, it is knocking on an open door. It is obvious. It is an obvious need. It's an obvious state of affairs, given the evolving of Parliament from when Parliament came into existence, given our independence from 1962 to now. Our needs have certainly become more sophisticated. The government's role has become more enlarged, and the executive play a critical role in almost all aspects of life, of national life, and therefore it is incumbent on a Parliament to be able to be well-resourced so as to keep government in check, so as to have government accountable for the trust that is placed upon them in terms of their resources, in terms of how they manage our economy. As you know, and we have heard many senators in these chambers speak about the mismanagement by successive governments that has formed government in Trinidad and Tobago, and the difficulty it is for members in kind of their functions of scrutinizing in the various committees that have been established under the Constitution, under the standing orders, to be effective. We have heard lamentations repeatedly about the roles that members of Parliament, certainly senators, play, that we are considered not to be legislators. And certainly, given when you look at the de facto operation or functions, we certainly operate as though we are full-time legislators. And that in itself, I mean, I don't need to go over traverse all that has been said, certainly the last comments made by Senator Ramdeen, where that is concerned. It is well known. We have been speaking about that, I think, since the 10th Parliament, and nothing has been done so far just to correct that anomaly. And hopefully, with an independent Parliament, these things will be addressed, and addressed in a sufficient way. I do not think that we need to go out and necessarily look at all the different studies that have been done in other jurisdictions to support the need for a parliamentary independence. What to me will be more germane for us is what shape it's supposed to take. Would it be a corporation, or what is the vehicle? What organizational structure? I think that should probably engage our concerns more than whether or not parliamentary autonomy is necessary. As I said, I think that we are all on the same playing field where this is concerned. We know there's a need for it. We also appreciate the fact that the staff that assists Parliament in functioning is one of the best staff you can find anywhere in public service in Trinidad and Tobago, and that is a given. And for that, I mean, one can only be anxious in seeing that they are adequately provided for in a new dispensation, in a new independent parliamentary setting. I am struggling, as you see, to find new things to say about the need for the parliamentary autonomy, simply because all that has need to be said about it has been said already. But I thought it necessary, given the importance of it, given the fact that I view this debate as one of the more non-contentious debates, and one that is quite enlightening, and one that is also necessary for us moving forward and strengthen our democracy, that I will just add my 2 cents. But having said that, Madam President, I look to, I will say that one of the critical hindrances in any administration, as Senator Obika has said as well, I mean, I will just use the old adage, is that he who controls the purse controls the sea. And therefore, if we have a parliament that controls its own finances, independent of the executive, and not operate as de facto the government department, I can only see the enormous benefits that have all been elaborated here for the independence of Parliament being an urgent item to be secured in this 11th Parliament. Madam President, I would not detain you much longer, nor the Senate, because, as I said, all that needs to be said has been said about this, and I am all for the independence of Parliament, and that it be sooner than later. I thank you.
Senator Mark.
Thank you very much. Madam President, I'm very grateful and happy for the opportunity to make my closing comments on this very significant debate that we have engaged in for the last 3 private members' sittings of our Honorable Senate. I also want to take the opportunity from the outset to register and record my appreciation to the 17, almost 18 members, because I'm speaking twice. And I have my colleague who has indicated to me he would like to speak after me. That is the Honorable Leader of Government Business, which would make us 19 members contributing to this matter before us. Madam President, let me say that this matter of parliamentary autonomy or independence is, as Senator Clarence Ramrat said in his contribution, did not start in 2010. It started long before 2010. I recall being chairman of the Joint Select Committee back in 1997 when Lawrence Raj, through the UNC, moved for a new management structure for the Parliament of the Republic of TNT. We didn't complete the work then, Madam President, and we didn't complete it also in the 10th Parliament. Suffice it to say, Madam President, that this exercise that we are engaged in today has been going on for close to 21 years in our Parliament. So it is not an overnight debate or exercise. And, Madam President, I think it's very important from the very outset to refer to the very report that my colleague referred to earlier in his contribution. That is the report of the JSC, appointed to consider the legislative proposal entitled the Draft Houses of Parliament Service Authority Bill 2014, and to put onto the record of this Honorable House, when we talk about parliamentary autonomy, what are we referring to? So it could be, as the former Prime Minister used to say, Patrick Manning, be made pellucidly clear for all and sundry, Madam President. Madam President, I go to page 5 of this report, and it states under parliamentary autonomy the following. Parliamentary autonomy should be viewed not solely in terms of separation, but rather as a recalibration of the existing relationship between the executive and the legislature based on an underlying evolution in Parliament and state maturity. Basic requirements for parliamentary autonomy include the following, Madam President. Parliament should be serviced by a professional staff independent of the public service. Secondly, there should be adequate resources provided by the government and non-governmental backbenchers, provided to government and non-government backbenchers in order to improve parliamentary impact, and should include, for instance, the following provisions. Training for new members, secretarial office, library, and research facilities, drafting assistance, including private members' bills. An all-party committee of Parliament should review and administer Parliament's budget, which should not be subject to amendment by the executive. These are some of the features of parliamentary autonomy. And Madam President, we go on now to deal with some of the substantive features of an autonomous parliament. A parliament corporate body with the power to secure budgetary requirements without interference from the government. A parliament corporate body that is responsible for providing necessary financial and human resources to Parliament. An officer responsible for accounting for the financial resources provided by the corporate body for the parliamentary service, and an independent auditing arrangement. An independent Parliament staff set apart from any other service, owing loyalty to Parliament, and appointed strictly and transparently on merit. The rights of staff transferring from the public to the parliamentary service need to be protected. Clarity of functions and powers within the parliamentary administration, and especially between the political and official roles. And finally, a culture of accountability, transparency, and high ethics in all aspects of parliamentary administration. So, Madam President, I think we need to understand very early, from the very outset, that when we talk about parliamentary autonomy, these are some of the features that we are talking about. And as legislators, we have a duty and a responsibility to strengthen the parliamentary institution that we have come to be part of for all these years, and of course for the younger ones like Senator De Freitas, years to come. Madam President, I want to also indicate when Senator Clarence Rambarak made the question about what is so magical about our Parliament in terms of the professionalism of our staff that sets this staff separate and apart from the other members of the larger public service. I want to tell you, Madam President, without parliamentary autonomy, we have to take our hats off to the clerk of the House, Jackie Sampson Miguel, who has been laboring in the vineyard for as long as I can remember. And also, well, the clerk of the Senate is also important, but the clerk of the House is the accounting officer. So it is both clerks, but I'm dealing here with the clerk. Madam President, if we didn't have a strong, non-partisan, professional, independent, and impartial clerk of this House, of the Parliament, Madam President, we don't know what may have happened. And that is why, Madam President, the case for parliamentary autonomy is so important. Because if you don't have a strong, independent, impartial, non-partisan, and professional individual holding that reign, we could be anywhere. Madam President, I don't want to go very far to tell you what goes on in other Caribbean countries. You know, and many members here know. So we must be proud that we are here today, and we are here and doing what we are doing because of a very strong parliamentary staff. I include the board clerks, Madam President, and I include the staff of our Parliament as well. So there's no magic about it. There is a lot of strength in the very human resource base that make up our parliamentary system at this time. And therefore, it really strengthens, Madam President, the need and the call for this independent parliamentary institution that we are all striving to realize in this country. Mr. Vice President, I would like to take you to a document called Recommended Benchmarks for the CPA Caribbean, Americas, and Atlantic region. This was first endorsed in March of 2011 by the clerks of the Caribbean and later by presiding officers in 2011, and then subsequently endorsed and approved by a regional CPA meeting on the 29th of June 2011 in Grenada at the 36th CPA Regional Conference. And Mr. Vice President, one of the areas that we see here in this document under Article 5.4 is called Organization and Management. And it says the following: there shall be established a parliamentary corporate board. Now, when we talk about the Caribbean, the Atlantic, and the Americas, we are talking about all those parliaments within those areas of the Caribbean, the Atlantic, and the Americas. And we have all agreed to be guided by these benchmarks and move towards implementing these benchmarks into legislative format. So under Article 5.4, Organization and Management, we have all agreed to implement. There shall be established a parliamentary corporate board by legislation that shall be responsible for the management of the legislature. It goes on, Mr. Vice President. Each legislature shall have an office of clerk, which should be a permanent, non-partisan office with the principal responsibility to provide advice on rules of procedure to presiding officers and members. Legislation should provide for a parliamentary service and establish a corporate body responsible for the recruitment of the clerk and the determination of the Parliament's budget, as well as providing general governance over the parliamentary protective status to prevent undue political pressure. It goes on, Mr. Vice President, as example, the terms and conditions of presiding officers shall not be less than what is applicable to members of Parliament, of cabinet rank. This is a benchmark that we have established in the Caribbean, that no presiding officer should get less than the salary of a cabinet minister. We don't have that, Mr. Vice President. This was agreed since 2011. We don't have it, Mr. Vice President, okay? And Mr. Vice President, I could go on, but I'll stop at this point to let you know that we need to recognize that the whole thrust towards parliamentary autonomy has been well established. Mr. Vice President, may I also tell you that the Latimer House principles that my colleagues have referred to arose out of a Commonwealth Heads of Government meeting, which was held in Abuja, Nigeria, in December of 2003. The basis for the Latimer House Principle arose out of that meeting. And that meeting saw Trinidad and Tobago signing off on the principles and guidelines. And that was the Honorable Patrick Manning. That was in the year 2003. So since 2003, Trinidad and Tobago, Mr. Vice President, had agreed to the Latimer House Principles of the separation of powers and the independence of the judiciary, the executive, and the legislature, and why we must have institutional, administrative, and financial independence and or autonomy. These things were well established. So we are just regurgitating, Mr. Vice President, what already exists. And Mr. Patrick Manning signed this document in Abuja, signed off on the principle that we should deal with the separation of powers in terms of the principles of the separation of powers, giving Parliament that degree of independence. But you know, Mr. Vice President, tragically and unfortunately, between 2003 to 2010, I'm afraid to report, nothing was done to strengthen the Parliament. And even though we had signed off on this Abuja agreement that gave rise to the Latimer House Principles, we did not do anything to bring about a strengthening of our Parliament, to make our Parliament more independent of the executive, Mr. Vice President. And it is never late. It is never too late. We are starting a bit late off the block, 20 years after, from 1997, and from the Abuja experience, 2003. We are in 2018, so we're talking about 15 years later, Mr. Vice President. Mr. Vice President, I want to take you back to a workshop on parliamentary committee system held in Trinidad and Tobago. It was held in your beautiful island of Tobago. It was on the 20th and the 21st of March, 2006. And these are the principles and recommendations that were agreed upon since 2006. Madam President, since 2006. I will just read one of those principles because there are about 2, 4, 6, but time would not permit me, Madam President, to go through all. Here are one of the principles, Madam President. The Parliament of Trinidad and Tobago should be exclusively responsible for the internal management and governance of its administration. Madam President, this was a principle agreed upon since 2006. And Madam President, here are some of the recommendations arising out of that workshop that was adopted by the Parliament of the Republic of TNT. 1, the number of members serving in the legislature should be increased inter alia to provide sufficient membership for the parliamentary committee system and to strengthen the parliamentary oversight role. So, Senator Rambarat, you made reference to the European Commission report, and they talk about the smallness of size and the numbers and the challenges. But here in 2006, Madam President, even before that report of 2012, we had agreed in principle that one of the recommendations we should pursue, Madam President, is increasing the number of MPs. We moved from 36, Madam President, to 41, and that was a result of the 1818 debacle that we experienced in 2001. But you know what? Surprisingly, the Senate, the number in the Senate has never moved. So, Madam President, even though we moved from 36 to 41. We remain static, and the opposition remains 6, the independent remain 9, and the government remain 15. And of course, the president is number 16. So in other words, there should be a proportionate increase. So as we increase the number of seats in the House of Representatives, there should be a concomitant increase in the number of senators in our country. But we have remained static, Madam President. Madam President, we had recommended in 2006 the role of an MP should be recognized as a full-time occupation. Since 2006, we recognized that, and we made a recommendation. Parliament should review its corporate structure to meet the challenges or the challenge of managing more effectively its administration and financing. And here is one, Honorable President. Parliament should consider modernizing the standing orders of both houses. Since 2006, we only modernized our standing orders in 2014 and gave effect. Well, in 2015, it was done in this House, and it was only given effect when we began our 11th Parliament. Madam President, I raise these matters. Another principle, Madam President, and I think Senator Ramsey made reference to it. We all agreed in principle, and a recommendation was advanced. Cabinet members should not be appointed to oversight committees. That's a principle and a recommendation. But we have 4 cabinet ministers chairing 4 joint select committees: foreign affairs, energy and energy affairs, human rights and diversity and inequality, and the other one is national security. And we agreed in 2006, Madam President, that no cabinet member, minister, should be a member of a joint select committee. Should be appointed, should not be appointed to oversight committees. That was a principle and a recommendation. And yet still, Madam President, we still have cabinet. So, Madam President, here the oxymoron, here the contradiction, Madam President, here the conundrum, literally. We have to inquire and scrutinize the executive. The executive is now in charge of a committee of the Parliament that's supposed to be scrutinizing the executive. How can the executive sit in judgment of itself? So I'll just give you an example, Madam President, of some of the things that we had agreed to. So, Madam President, I want to also indicate that one of the challenges that we have in Trinidad and Tobago, and I read in the newspaper with great interest this week, an article in yesterday's Newsday, Monday, April 23rd, by Mr. Reginald Dumas. And he talked about institutional and governance impairment. And, you know, he made a very significant point, Madam President. I just want to quote the first 2 paragraphs of his article. He said, "For years now, I have been warning of decline in the quality of our institutions and of our governance structures and implementation. The areas to which I principally speak strike me as increasingly deaf. Worse," he said, "in too many instances, those who are directly charged with the task of protecting and strengthening those institutions and of providing good governance are themselves the vanguard of the assault on the institution and the cynical proponents of improper, often bad governance. There have been some recent examples," and he went on. So, Madam President, what I'm saying is that our institutions have come under assault. And what Mr. Reginald Dumas is saying, the people who are supposed to be in the vanguard of protecting our institution, they are in the vanguard of assaulting and eroding those institutions in our country. And he's talking about the government of the Republic of Trinidad and Tobago, because he went on to give examples of it. So I'm just giving you, Madam President, Somebody made the point that outside of the Parliament, there's no other institution in this country that can rival our Parliament. Madam President, could you imagine that you have a situation where a government institution can advertise for a post, and before the post could be filled and applications entertained and interviews conducted, the institution appoints somebody? Madam President, isn't something wrong with that? How can you advertise for a post, and when you are applying for the post, Madam President, you read in the newspaper that Mr. John Harry has been appointed general manager to this post? That can only happen in a government-led institution. That is what Mr. Dumas is talking about. So Mr. Charles Mitchell is now the general manager of the PTSC. What? And Madam President, an advertisement was put out, and it was closed on April the 20th. But Mr. Charles Mitchell was appointed general manager on the 16th of April, even though the advertisement for applications closed on the 20th. Madam President, something has to be wrong. And when Mr. Dumas talks about the decline in the quality of our institution, it is these things, Madam President, that he's referring to. And the government must take stock of this. The government must take stock of it. And Madam President, before we go for tea, I just want to say in closing, before I use up my next 10 minutes upon resumption. Madam President, may I simply say, before closing, that one of the things that I would like to suggest is that the emoluments of the President of the Senate, the Speaker of the House of Representatives, and the clerks, both the clerk of the House and the clerk of the Senate, be a direct charge on the consolidated fund of our country. They must become direct charges so that they don't depend on the whimsical movements of a Minister of Finance, no matter who that Minister of Finance may be. Thank you very much, Madam President, for your time.
Honourable Senators, we will now suspend. Senator Mark, you actually have used up 29 minutes, so you have 16 more minutes when we resume. So we will suspend until 5 p.m.